Okay, brace yourselves, because medieval marriage was a whole different ballgame. Imagine this. Your husband could legally correct you with a stick, provided it wasn't thicker than his thumb. Yoicks. And that hefty dowry your parents paid? Or any money you earned yourself? Poof. It mostly became his property the moment you tied the knot. Thinking of making a will or suing someone? Not without his permission, sweetie. Wild right. Number 9. So you thought you could just pick your hubby. Let's talk about saying "I do" in the medieval world. If you were a woman, the chances of you picking your own partner like you're swiping on a dating app were, well, pretty slim. For most medieval gals, especially those from families with a bit of land or money, marriage was less about romance and more about strategy. Think family alliances, consolidating property, or securing a nice, stable future. Your parents, particularly your father or other male guardians, usually had the final say. They'd be looking for a good match that benefited the family and your personal preference. That often came second or third, or maybe not at all. Now, the church, bless its heart, did say that both the bride and groom had to consent to the marriage for it to be valid. This was a big deal, in theory. It meant that, technically, you couldn't be forced to marry someone if you stood at the altar and said, "Nope." Your whole family, the community, everyone expecting you to go through with it. A young woman trying to defy her powerful father or the local lord. That took some serious guts, and it didn't always end well for her. Sometimes, a rebellious daughter might find herself packed off to a nunnery if she refused a strategic match. The age for marriage was also pretty eye-opening. Canon law, which was the church's law, set the minimum age for marriage at 12 for girls and 14 for boys. Yep, 12. While many people, especially peasants, might have married a bit later in their late teens or early 20s, noble and wealthy families often betrothed their children much younger to seal those important deals. These were essentially promises of future marriage, and sometimes the kids would even be raised in their future in-laws' households. So, while the idea of consent was there floating around, the reality for many medieval wives-to-be was that their path to the altar was largely decided by others. It was about duty, family, and property. Finding true love was a bonus, not a requirement. If your family picked a decent guy, great. If not, well, you were generally expected to make the best of it. The system was designed for stability and the transfer of wealth and power, and individual desires often had to take a backseat. Could you imagine your dad picking out your future spouse based on whose farm bordered his? It was a different world, that's for sure. The power to choose a fundamental thing we take for granted was a luxury. Few medieval women, regardless of class, truly possessed when it came to marriage. Number 8. That rule of thumb thing and keeping you in line. All right, this one is a bit grim, so steel yourselves. The idea that a husband had the right to physically discipline or correct his wife was pretty widespread in medieval Europe. It wasn't seen as abuse in the way we understand it today. For many, it was considered a husband's prerogative, even his duty, to keep his wife obedient and his household in order. Sounds shocking. And it is, but it was embedded in the legal and social fabric of the time. Various legal codes and social customs across different regions acknowledged this right. For example, in some parts of France, it was stated that a husband could beat his wife reasonably. What reasonably meant could be horribly vague. Some texts even got specific, like the infamous, though its direct medieval origin is debated by some scholars, the principle was there, rule of thumb, suggesting a man could beat his wife with a stick no thicker than his thumb. Whether this was an actual widespread law or more of a grim saying, the underlying acceptance of physical correction was definitely present. The aim, legally speaking, was not to allow husbands to maim or kill their wives, but short of that, a lot could be permissible. Why was this a thing? Part of it stemmed from the whole husband as head of the household idea. The wife was expected to be subservient, and if she wasn't, the husband was seen as responsible for her behavior. Physical chastisement was one of the tools he supposedly had to enforce that obedience. Think of it as an extension of the idea that a father could discipline his children. The wife, in some legal senses, was almost like another child under his authority. Of course, this didn't mean every husband beat his wife, or that society universally cheered it on. There were moral teachings from the church that urged husbands to treat their wives with kindness and affection. Some conduct books advised against excessive violence, warning that it could breed resentment rather than obedience. But the crucial point is that the legal framework often gave husbands this power. If a wife was beaten, her options for recourse were incredibly limited. She could appeal to her family, who might intervene if they were powerful enough, or if the abuse was seen as excessive and shameful. She could complain to church authorities, who might try to mediate, or in very extreme cases, grant a separation, not a divorce, mind you. But proving excessive cruelty was hard, and the system was generally set up to preserve the marriage and the husband's authority. Imagine living with the knowledge that your spouse had a legally sanctioned right to hit you if he felt you stepped out of line. It puts a whole different perspective on marital disagreements, doesn't it? This wasn't about a specific right a wife had, but a terrifying lack of a right to bodily autonomy and safety within her own marriage, at least by our modern standards. The line between correction and outright brutality was often blurred, and the person drawing that line was usually the husband himself. Number 7, your paycheck. Honey, that's our paycheck, but mostly his. So, you're a medieval woman, and maybe you're super skilled. Perhaps you're an amazing weaver, a sought-after midwife, or you help run the family farm or workshop like a boss. You're bringing in the bacon, or at least the medieval equivalent, maybe some extra bushels of wheat, or a few silver pennies. But here's the kicker. Could you actually keep that money for yourself? For the most part, the answer was a big ol' nope. Under the widespread legal doctrine known as coverture, we'll dive deeper into this later, it's a doozy. Once a woman married, her legal and economic identity essentially merged with her husband's. And guess who was in charge of that merged identity? Yup, the husband. This meant that any wages she earned, any profits from a little side hustle she might have, technically belonged to him. He was the one who controlled the family finances. It wasn't like she had her own bank account to stash her earnings. Now, this doesn't mean women didn't work. They worked incredibly hard. Peasant women toiled in the fields alongside their husbands, managed dairy operations, tended gardens, and raised poultry. In towns, women were active in many trades. They were spinners, weavers, brewers, alewives were a common thing, bakers, and seamstresses. They often assisted their husbands in their crafts, and if a craftsman died, his widow might be allowed to continue the business, at least for a while, sometimes even becoming a member of his guild. These were the femmes women operating with a degree of economic independence, often because they were widowed or, in some specific urban contexts, granted special status to trade as if they were single, even if married, if their husbands were, say, abroad or consented. But for the average married woman working alongside her husband or earning a little extra, that income was absorbed into the household finances, managed by the man of the house. She couldn't independently decide to invest her earnings or buy property with them. Her economic contribution was vital, often the difference between the family thriving or starving. But her individual right to control the fruits of her labor was severely limited. Think about the implications. If you wanted to buy something special for yourself, or perhaps help out a needy relative, you'd likely have to ask your husband for the money, even if you were the one who technically earned it. This reinforced the dependency of the wife on the husband. While in a good marriage, resources might be shared and discussed, the legal power over those resources, including her earnings, rested firmly with him. Some women, particularly in towns or through specific customary laws, might have a bit more leeway with pin money or earnings from certain traditionally female activities. But the overarching principle was that the husband was the master of the household's economy. It's a world away from having your own direct deposit and financial independence. Number 6. Want to sue someone or sign a lease? Ask your husband first. Imagine needing to go to court because someone cheated you in a deal, or wanting to sign a contract to rent a small shop for your baking business. If you were a married medieval woman, you generally couldn't just waltz in and do these things on your own. Why? Because of a little thing called coverture. This legal concept, super common in places like England and parts of Europe, basically said that when a woman married, her legal identity was covered by or absorbed into that of her husband. They became one legal entity, and that entity was, for all practical purposes, him. This meant that a married woman, or femme covert, as she was known in Norman French legal terms, meaning covered woman, typically couldn't sue someone in court under her own name. If she had a legal grievance, her husband would have to bring the lawsuit on her behalf, or she would be joined with him in the suit. Similarly, she couldn't be sued alone either. If someone had a claim against her, they'd usually have to sue her husband. It was as if, in the eyes of the law, she didn't exist as an independent legal actor once she was married. The same went for making contracts. Want to buy or sell land? Take out a loan. Enter into a business agreement? As a married woman, you generally need your husband's consent and involvement. He was the one with the legal capacity to bind the household to agreements. Any contract she tried to make on her own could often be invalidated. This wasn't just about big things like land. It could extend to everyday commercial activities. There were, as always, some exceptions and variations. If her husband was exiled, had abandoned her, or was considered civilly dead, Like if he joined a monastery and took vows of poverty, a wife might sometimes be able to act as a femme sole, a single woman, in legal and business matters. In some towns, particularly for trading purposes, married women engaged in certain businesses might be treated as femmes, soles, regarding their trade debts and contracts, so they could operate more freely. This was practical. If a woman was running a pub, people needed to be able to make contracts with her for ale. But the general rule was clear. Her husband was her legal representative, her gateway to the formal legal and contractual world. This lack of independent legal standing had huge implications. It reinforced her dependence on her husband for almost all aspects of public and economic life. She couldn't easily protect her own interests, manage property she might have brought into the marriage, or engage in commerce without his oversight or permission. It's a stark contrast to today, where your marital status doesn't strip you of your basic right to interact with the legal and financial world as an individual. For medieval wives, their legal voice was often muted, needing to be channeled through their husbands. Number 5. Your word in court. Let's hear what a man says. So you witnessed a crime, or perhaps you were the victim of one. You go to court, ready to tell your story. But if you were a medieval woman, how much weight did your testimony actually carry? Well, it was complicated, and often not as much as a man's. While women could and did testify in court, their credibility was frequently viewed with a degree of skepticism, or at least as being inherently less reliable than that of their male counterparts. This wasn't usually a formal law saying, a woman's testimony is worth half a man's, though such ideas did exist in some legal traditions outside of mainstream medieval Europe or in specific contexts. Instead, it was more about societal attitudes and legal interpretations that often disadvantaged female witnesses. Women were stereotypically seen as more emotional, more prone to deception, or simply less rational than men. These prejudices could influence how judges, juries, where they existed, and legal officials perceived their statements. In some situations, a woman's oath might be considered less valuable than a man's. For certain legal procedures, the number of oath helpers, people who would swear to the truth of your statement, required might differ based on gender, or a woman might need more corroborating evidence for her claim to be taken seriously. A particularly tricky area was testifying against her husband. Under the principle of coverture, there it is again, husband and wife were considered one. This often meant that a wife couldn't testify against her husband in most criminal or civil cases, and vice versa. They were seen as having a unity of interest. There were exceptions, of course, particularly if the crime was against the king, like treason, or in some instances, if the case involved severe direct harm by the husband to the wife. But even then, it could be a difficult path. However, women's testimony was crucial in certain types of cases. For instance, in matters considered women's affairs, like childbirth, impotence, sexual assault, or domestic violence, female witnesses, especially midwives or respected matrons, could be very important. Their knowledge and experience in these areas were recognized. In cases of rape, a woman's testimony was central, though proving it could be incredibly difficult and often required immediate reporting, evidence of struggle, and a good reputation. If a woman was deemed of ill repute, her accusations were far less likely to be believed. So, while women weren't entirely excluded from the witness stand, their voices often carried less inherent authority. Their gender could be a factor in how their truthfulness was assessed. It wasn't a blanket denial of their ability to speak, but a subtle, and sometimes not so subtle, devaluing of their word compared to men, reflecting the broader patriarchal attitudes of the era. Being believed, truly believed, in a formal legal setting, could be an uphill win for many medieval women. Number 4. Till death do us part. Usually meant exactly that. Thinking about getting a divorce in medieval times because you and your hubby just weren't clicking. Well, you'd better think again. Divorce, as we understand it today, a legal dissolution of a valid marriage allowing both parties to remarry, simply didn't exist in Christian Europe during the medieval period. The Church taught that marriage was a sacrament, a holy bond created by God, and what God has joined together, let no man put asunder. So, once you were married, you were generally married for life. But what if things were truly, horrifically bad? Or, what if there was a really good reason why the marriage shouldn't have happened in the first place? There were a couple of options, but they weren't easy or common. Getting an annulment was often a lengthy, complicated, and expensive process, usually only accessible to the wealthy and powerful who could afford the lawyers and court fees. And even then, success wasn't guaranteed. For kings and high nobles, an annulment could be a way to get out of a politically inconvenient marriage or to try for an heir with a new wife, but it was a big deal. What if the marriage was valid, but life together became unbearable due to something like extreme cruelty or adultery? In such cases, the church courts might grant a separation from bed and board or divortium a mensa et thoro. This allowed the couple to live apart, but they were still legally married. Crucially, neither party could remarry as long as the other was alive. The wife might receive some form of maintenance, alimony, but it was often meager, and she might lose custody of her children. Life for a separated woman could be very difficult, socially and economically. So, for the vast majority of medieval wives, till death do us part was the literal truth. Even in an abusive or desperately unhappy marriage, there was often no easy way out. The emphasis was overwhelmingly on preserving the marriage bond almost at any cost. The modern idea of ending a marriage simply because of irreconcilable differences was completely alien to the medieval mindset and legal system. Number 3. Want to vote or run for office? Keep dreaming, lady. If you were a medieval woman wondering about your role in the government or having a say in how things were run, the answer was generally pretty straightforward. That wasn't your department. Political rights as we understand them, like voting, holding public office, or participating directly in lawmaking, were almost exclusively the domain of men. The medieval world was structured hierarchically, and within that structure, men were seen as the natural leaders in the public sphere. A woman's place was primarily considered to be in the home, managing the household, raising children, and being subservient to her husband or father. She was a subject of the king or lord just like men, but her direct participation in the machinery of governance was virtually non-existent. There were no elections in the modern sense for most positions. Kings inherited their thrones, lords held their lands by feudal ties, and town councils were often made up of prominent male merchants or guild masters. Women were simply not part of this equation. They couldn't sit on juries in most places, though sometimes women of high standing might be called upon in specific cases involving other women, like determining pregnancy. they couldn't become judges or magistrates. The idea of a woman being a knight, a sheriff, or a royal advisor in her own right was, with extremely rare exceptions, unthinkable. Now, this doesn't mean women had zero influence. Noblewomen, especially queens, queen mothers, or powerful duchesses and countesses, could wield considerable indirect power. A queen might influence her husband the king, act as a regent for a young son, or manage vast estates if she was a wealthy heiress or widow. These women were exceptions due to their birth and rank, and they operated within a system that still formally excluded women from power. Their influence was often personal, through their relationships with powerful men, rather than a formal, recognized political right. Even for ordinary women, there were perhaps very localized, informal ways they might make their voices heard on community matters, perhaps through their husbands or in women's groups or guilds, where those existed for women. But a formal, legal right to participate in the political process, not a chance. The concept of citizenship itself was different. It was more about belonging to a certain community or kingdom and fulfilling your duties within your prescribed social role, rather than possessing a set of active political rights. For a medieval wife, her legal and political identity was largely subsumed under her husband's. He was the one who represented the household in public life, who might hold military service or participate in local assemblies. She was, in a political sense, largely invisible. The levers of power, the making of laws, the administration of justice, these were firmly in male hands. The idea of universal suffrage or equal political opportunity for women would have seemed like a bizarre fantasy. Number 2. Your stuff, his stuff, and what happens when he's gone. When a medieval woman got married, the question of what's hers and what's his became pretty important, especially since, as we've seen, her husband generally gained control over most things. But there were some specific concepts around property and inheritance that were crucial for a wife, particularly concerning what she brought into the marriage and what she was entitled to if her husband died. First up, the dowry. This was the property, money, goods, land that a bride's family gave to her, or rather to her husband or the new marital household, upon marriage. It was a very common practice across all social classes, though the size and nature of the dowry varied wildly. For the nobility, it could involve huge estates and vast sums of money used to forge alliances. For a peasant girl, it might be a few animals, some household linens, or a small plot of land. Legally, the dowry was intended to support the wife during the marriage and was, in theory, supposed to be returned to her or her family if the marriage ended without her fault, or if her husband died before her. However, during the marriage, her husband usually had full control and use of the dowry. He managed it, and any income from it was his. Protecting the dowry from a spendthrift husband could be a real concern for a wife and her family. Then there was the dower, not to be confused with dowry. This was perhaps one of the most significant legal rights a medieval wife possessed, though it only kicked in if she outlived her husband. Dower was the portion of her deceased husband's lands and property, often a third, but it could vary by region and custom, that a widow was entitled to use for the rest of her life to support herself. This was a big deal. It provided a measure of security for widows. She couldn't sell the dower lands. They would typically revert to her husband's heirs after her death. but she had the right to the income and use of them. This right was usually established at the time of marriage, often, literally, at the church door. Husbands couldn't easily sell or give away property that was designated as part of his wife's potential dower without her consent. This gave wives a little bit of leverage. What about inheriting from her own family? Yes, a medieval woman could inherit property from her parents or other relatives, especially if she had no brothers. Primogeniture, where the eldest son inherited most or all, was common, but rules varied. However, under coverture, any land or significant property she inherited during her marriage would usually come under her husband's control and management. He would be entitled to the income from it. She couldn't sell it or dispose of it without his agreement. And what about making a will? Could a married woman decide who got her stuff? Whatever little stuff she could claim as her own, like personal clothing or jewels, sometimes called paraphernalia, after her death? Generally, no, not without her husband's permission. Since most of what she might have owned was legally considered his, or part of the joint marital property controlled by him, she didn't have the independent right to bequeath it. If she died before him, her personal possessions often just remained with him. So, while a wife brought resources into the marriage, dowry, and had a potential claim to support after her husband's death, dower, her ability to independently own, control, or dispose of property during the marriage was extremely restricted. It was a system designed to keep property within families and under male control, with the dower right being a crucial, if limited, safeguard for widows. Number 1. What's yours is mine. The ultimate guide to coverture. We've mentioned this word coverture a few times, and it's so central to understanding a medieval wife's legal non-existence that it deserves the top spot. Imagine you're a woman, single and of age. You might have some legal rights. You can own property, make contracts, maybe even run a business. But the moment you say, "I do," and get married, a legal cloak called coverture descends upon you. And poof, a lot of those independent rights vanish. Or rather, they get absorbed by your husband. In legal systems like English common law and similar concepts existed across much of medieval Europe, coverture meant that the husband and wife became one single legal person. And who was that one person in the eyes of the law? You guessed it, the husband. The wife's legal identity was covered by his. She became a femme covert, a covered woman. Her husband became her lord, her master, her legal representative, in almost all things. This doctrine of coverture wasn't necessarily designed to be deliberately cruel in its origin. It evolved from feudal ideas about land tenure and family structure, where the man was the head of the household and its representative in the wider world. It was about creating a single, unified economic and legal unit, the family under male leadership. However, the impact on wives was profound. It meant a near total loss of legal and economic autonomy. Her existence, in many formal legal ways, was secondary to and dependent upon her husband. She was not her own woman, legally speaking. While the reality of daily life and personal relationships could be much more nuanced, with wives often playing vital roles and wielding informal influence, the legal framework of coverture put medieval married women in a position of significant legal subordination. It's a concept that shaped the lives of countless women for centuries, and understanding it is key to grasping just how different their world was from ours. The idea of being a separate, independent individual with your own full set of rights simply didn't apply to most married women in the medieval era.